You want to break?
Yeah, that's okay. We can do it.
Okay. First, Business Bank versus Stone Lock Global. And Mr. Larson, did you want to reserve any time for rebuttal?
I'd say 3 minutes, please.
3 minutes, okay. You got it. Start whenever you want.
Thank you, Your Honor. Good afternoon, members of the court. May it please the court. We are here on summary judgment, as the court knows. So court's
Right.
review is
De novo.
and unlimited. So we'll get all the obvious things out of the way.
Right.
The thrust of our case on appeal, and I'm here on behalf of Mr. and Mrs. Dunlap, the property owners, is that the district court failed to consider important evidence, and in fact, specifically rejected important evidence, and therefore made its conclusions based upon what we consider an incomplete and inadequate record. Specifically, and with the objective being in this and any other case of its kind, to do what can be done to arrive at the intentions of the parties. So, number one of the two pieces of evidence that the district court excluded was the declaration of Colleen Dunlap that was presented correctly via the response to the summary judgment on the second summary judgment motion, of course, of what we're talking about. And you've seen in the briefing that the parties agree on the impact of the failure of the movement to respond to that and provide evidence. Well, there's no doubt that they did not come back and respond with any contradictory evidence, and they had a duty to do so. And their failure to do so renders that declaration a true statement for purposes of this appeal. That's our position.
Okay.
Question, Your Honor. So,
No, go ahead.
all right. And we've cited case law to this effect. The Carr case, among others, places that obligation upon the movement where the party against whom summary judgment is sought comes forward with their own statement of facts. It's a very common occurrence. So here,
So I have a question.
Yes, Your Honor.
This evidence was excluded by the court on the basis of the parole evidence rule, right? And also the court made a finding that it was inadmissible hearsay.
yes,
That's two different findings, right?
yes.
And you challenged one and not the other.
We challenged the ruling in its entirety,
Okay.
her exclusion of that, and we did address the hearsay in our brief.
Okay.
Do you think you made a hearsay objection to the district court on this issue?
I was not,
Response to the hearsay objection.
Right.
you know, the way it was presented, there's nothing written to that effect, because our only filing in the lower court was the response to the summary judgment motion.
Oh, is
In that response,
testimony.
correct. Yes. So, but to address the specific bases for the court's exclusion of this evidence, as we've pointed out, there is a specific applicable exception to the parole evidence rule that governs here. And that being that the general rule on parole evidence does not apply when the evidence tends to show the relation of the parties and the circumstances under which the contract was executed. That is exactly what this declaration does. As to the hearsay argument, so to put a pin on that, parole evidence rule does not apply here. The court should have considered it, at least absent some other objection.
Right.
The only thing,
That gets us to the hearsay one.
yes, and so that gets us to the hearsay. again, as we pointed out in our briefs, specific exceptions to the hearsay rule are admissions against interest and statements against interest. Now here we have the statements of this Altera Bank representative, one who signed the actual loan agreements as, and again, as the SBA relations manager for Altera Bank. At a very minimum, he has apparent authority to bind the bank in his dealings with these folks. And when they were in the throes of agreeing to a massive obligation in these loan documents, as well as an intrusion on their home in the way of a mortgage, they had questions like I think any of us would. The question is, it says it's limited to $100,000. That's what the SBA mandated in their documents, which were also excluded. So are we at risk for any more than that, in essence? And his answer was no. So, what is the takeaway from that if you're the borrower? Because you want to know what your rights and duties and obligations are going in. And when you get that type of information, that goes right to the heart of their intent in going forward with the agreements. And I would say this, my esteemed opponent has said, well, you're reading too much into her declaration. And I would take the position it's abundantly clear under the circumstances in which it was presented that the bank was coming at them with an argument that was a polar opposite of what was represented to them prior to the execution of the loan documents and the agreements themselves. And so I don't think there can be any other conclusion drawn as to what the message was in that declaration. But I would add to this, and therefore I think it is ripe and appropriate for you all to come in and consider that in your de novo review. But if, as my opponent points out, well, it's unclear and it's ambiguous, what is the meaning of this declaration? Well, that is the very essence of a statement of fact that renders summary judgment inappropriate. So in our view, at a very minimum, this case should go back to the district court with instructions to work up this issue. But if they need to, the Dunlaps need to say more and testify about that, they certainly could. Presumably someone could track down this Mr. Thompson, the person who made the statement. And if that's what is required, we don't think that's what is required here. We think what is being said in this declaration, it's abundantly clear that intentionally or not, they were led into a decision to go forward with this. And they would not have made that decision with contrary information. So unless there's any questions further on that particular issue, I can talk about yes, Your Honor.
The contention would be that when a lender gets a loan, when someone receives a loan and it says it's for $100,000, and they say, okay, so this is the total amount, that the bank would say, well, yes, unless of course you default, and then we have to pursue, and then there's fees and such for pursuing, then you might have to pay those.
Well, I think the clear implication of the question is, in the event of that, what is our downside risk?
Right.
I mean, that was the objective of the question. And if I'm sitting in the shoes of of the SBA loan manager, I'd say, well, no, you're obligated for that, plus attorney's fees, interest that's going to continue to accrue until and unless the bank ever decides to foreclose, which has not happened yet. So the total amount of the obligation for the district court is really unknown as we stand here, but we know it's a minimum of some 280,000 on top of the 100,000.
On top of the mortgage amount.
Yes. So,
Do you think there's a difference in the attorney's fees versus the interest? For example, in that statement of, no, you're on the hook for $100,000, because you know, if the bank doesn't ever foreclose, I guess the interest could just keep going. But the attorney's fees, there'd be no way a banker would know, you know, that a person was going to require them to incur that amount of attorney's fees.
well, I think the response would be, it's not limited to $100,000. At a minimum, interest on the main note's going to be tacked on in the event of default. And there could be other things in there as well that he should have known, he could have figured out, but regardless, this is how he responded. And I have to repeat what I said in our brief. And I do not wish to attribute nefarious intent on this gentleman. But having said that, the bank stood to make almost $200,000 for a loan origination fee. So it was clearly in their interest to get this thing
Signed.
closed and signed up, yes.
Okay, so when you brought this case, did you argue that the loan documents were ambiguous, or did you believe the loan documents are not ambiguous, it limits it to $100,000?
I was not the attorney on the underlying matter.
You know, as appellate judges, we hate that more than anything else. Anybody to pawn it off on trial counsel.
We're in agreement.
Go ahead.
I hate that being on this side of it. But
do you know, I mean, I'm sure you read the record. I believe their argument was that the loan documents were not ambiguous. The loan documents said $100,000. It was a limit to $100,000, so it was not ambiguous.
from our side's point of
Right.
view, yes.
But now you're arguing that ambiguity supports the introduction of this parole evidence, correct? So I'm just trying to understand, is it ambiguous or is it not ambiguous? And isn't that kind of a foundational argument?
The first question, I think, is for the court to decide.
I'm arguing, what did you argue? You wanted the district court to find it wasn't ambiguous. It says $100,000, not an ambiguous.
The argument was on its face, this is what should be the ruling.
On its face, this document is not ambiguous. It's limited to $100,000.
Part of the problem is that was based upon, in part, on a document that was excluded by the district court.
Well, you only get
It's the loan
this
authorization.
other stuff in if you don't get any outside evidence in unless you show or argue there's an ambiguity, right?
Not necessarily. No.
Okay.
I don't agree with that respectfully. The parole evidence rule exception that I quoted is applicable irrespective of whether there's ambiguities or not in the document.
So just to distill that down, you did or did not say that it was straight 100,000, that there was no ambiguity? Not you personally, I get that.
Well, yes, the argument was the way in which the mortgage reads and the way in which the SBA loan authorization read, there's a mortgage cap of $100,000, period.
So the argument was never made that it was ambiguous.
The ambiguity argument for all of the loan documents itself was not presented, to my understanding, by my predecessor.
I think that's correct.
But I do,
But
Your
your
Honor, I do suggest that that is a different
question,
question as opposed to does this declaration are there ambiguities in it that would create an issue of fact? I think those are
right, I agree. Those
separate
are
issues.
different issues, right? Okay,
And the other leg of our argument, Your Honors, is the exclusion as to the heretofore referenced SBA loan authorization. And we find it hard to understand why that wouldn't have been considered part of the loan package. It was specifically referenced in the loan agreement. It was referenced in the recitations, the recitals. It was attached as an exhibit. And the recitals were adopted by incorporation into the loan agreement. So we think it's abundantly clear that the loan authorization document itself should be part of the record that formulates the basis of any evaluation here of the Dunlap's
Do you
obligation.
think the district court considered it though? Even though they said it was excluded?
There's no evidence that she did. If she took it into account, that's something I can't say, but it was not the basis of her record of her judgment.
Okay.
And again, the importance of that and why it's raised as just second of two appellate issues is that the mortgage was required by the SBA. And it was the SBA who told the bank, you have to do this. And if you want us to be a part of this loan, you have to do this. And when the language of the SBA loan authorization says that
The lien. is
The-
limited.
I'm saying, yeah, the third mortgage, including water rights, if any, on land and improvements located at their address on Granada Circle in Leawood, this lien is limited to $100,000. I would hazard to say that most people, myself included, would think, well, okay, that's SBA saying that's the most I'm going to have to pay in the event of default.
again, no ambiguity. That's what it says.
That is what it says. It was excluded, but that is what it's,
Oh, that
yeah.
was in her affidavit.
That was in the loan, the SBA, the
Oh,
loan
okay,
authorization.
and that was excluded too.
Yes,
Okay,
yes, Your Honor.
got it.
And so,
Is the lien different than total liability on a judgment?
you know, thankfully, I'm not a lawyer who practices in this type of commerce, but
Okay.
we're dealing with here, the word lien and credit are being proposed to be used interchangeably. I wouldn't know why you wouldn't just use one or the other and then define it.
Right.
And in these documents, the term credit is what's used in their mortgage papers, and yet credit is not a part of their definitions, whereas lien is, and lien is the word that's used by the SBA. So I can't square those, honestly, Your Honor.
And I'll still give you your rebuttal, but
Thank you. Yes.
Okay.
Thanks.
and I'll give you a extra. Were you trial counsel or?
I was.
Oh, good.
So feel free to pepper with questions. May it please the court, Your Honor, Andrew Nazar Polzinelli for First Business Bank. It's an
Mhm.
honor to meet you all. This appeal is narrower than the numbers suggest. Appellants don't challenge the underlying debt and judgment of over $1.7 million that was awarded. They don't challenge the interest that was awarded. They don't challenge the attorney's fees that were awarded. They don't challenge their default, the terms of their unconditional guarantees guaranteeing all of those amounts, or all the terms of the mortgage with the exception of the mortgage cap. What they asked this court to do today is to transform a $100,000 principal cap into an all-in cap that the clear language of the documents just does not provide. Examining the language of the mortgage cap, Your Honor, which is critical in this case. The mortgage cap states, and I'm going to avert my eyes so I can read it explicitly here. This third mortgage secures credit in the maximum amount of $100,000. Loans and future advances up to this amount, together with interest, are senior to indebtedness to other creditors under subsequently filed or recorded mortgages.
Priority.
Priority. But, Your Honor, critically, appellants, either in this court or at the trial court, did not argue the definition of the word credit. They did not examine it. Your Honor, we did, the trial court did. Second, Your Honor, as to the second sentence, up to this amount together with interest. When it's saying this amount, it's referring to the $100,000 amount in the previous sentence. Just grammatically, that makes sense. Adding then together with interest, which this court in other opinions has said is in addition to. So clearly, the credit of $100,000 does not include interest by that. Appellants attempt to rely on the SBA authorization and Ms. Dunlap's declaration asserting that the mortgage is limited to $100,000. And even if the court considers both of those and accepts every word is true, that doesn't change the outcome here, and it doesn't give the appellates what they hope it would. It doesn't create a material factual dispute and does not establish error warranting the overturning of the district court's grant of summary judgment. Again, Your Honor, the statement that the mortgage is limited to $100,000 is an ambiguous statement. And it's critical that this court understand at the time, again, SBA authorization, and assuming the statement is true and correct, was made, it was at the signing of a $5 million loan. And so that, and no party is disagreeing that the principal of that mortgage is limited to $100,000. So as to the statement that the lien is limited to $100,000, if you're talking about principal, we absolutely agree. The mortgage lien is limited to $100,000 in principal. So let's start with examining the language the parties actually signed, which, as Kansas courts instruct, is obviously the best place to start when determining parties' intent. It's helpful to start examining the rest of the language of the mortgage before we jump into the mortgage cap. It is clear and undisputed that Section 2A of that mortgage secures all debt. So that entire $1.7 million, all interest, all attorney's fees, is secured under that mortgage under Section 2A. Also, and here as to, we're going to talk about the loan agreement. The loan agreement is incorporated in certain respects into the mortgage. That is Section 10 of the loan agreement by its terms. And then at the end, that last provision of the third mortgage, the definitions of the mortgage or of the loan agreement are incorporated into the mortgage. Okay. The entire loan agreement is not incorporated into the mortgage. But what those definitions and what the terms in Section 10
By
provide.
saying that, you mean that it specifically says Section X of the loan agreement is incorporated herein?
Yes.
So it does it by section or whatever.
Correct.
Okay.
And so, Your Honor, Section 10 has a whole list of provisions, including the provisions for attorney's fees here. So to state the stage here, the mortgage is not ambiguous and it's not silent on these terms. There is explicit language both in the mortgage and incorporated thereinto that says this covers all of these debts. So there can't be any argument later that it's silent. The appellate cites several cases about silence and parole evidence. This mortgage is very clear and explicit in what it covers. Second, turning to the mortgage cap. Let's start with the exact noun that's capped. It secures credit in the maximum amount of $100,000. Doesn't say indebtedness. Doesn't say all secured obligations. Doesn't say total amount recoverable is capped at $100,000. In the commercial loan context, credit refers to funds advanced or principal. Appellates at the district court level or in the briefing to this court have not addressed the definition of the word credit. Under Kansas law, and I agree, and we argued to the court, it wasn't defined in the mortgage or in the loan agreement. So using plain and general definitions of the term We learned to Oxford English Dictionary, Merriam-Webster, Black's Law Dictionary, means the availability of funds or the provision of money. Again, principal on the loan. We cited some legislature statutes as well as where the legislature, when using the term principal, means money advanced on a loan. Again, appellant silent to these authorities, and thus we'd say they waive the argument as to the most critical term here in front of this court. Third, Your Honor, analysis of creditors' principles also confirmed in the next sentence, as we mentioned in my intro here of the mortgage cap. It refers to loans and future advances up to this amount, together with interest. So when the phrase says up to this amount, it modifies loans and advances in that $100,000 number. It's separately identified interest. So clearly the $100,000 number credit term does not include interest. Otherwise, that phrase would be superfluous. Now, I recognize that this sentence addresses priority, but its grammar informs the first sentence and the meaning of credit in this amount. Thus, that interest is separate from $100,000. Appellates want to argue that this sentence only applies if there's a fourth lien, but the structure of that sentence is not contingent upon there being a fourth lien. It doesn't say in the event there is a fourth lien, the following shall apply, some sort of trigger event. And this was part of the primary analysis relied on by the district court and not addressed by appellants here or in this court below. We've also cited, Your Honor, in re-protest of Barker case. And in that case, the Kansas Court of Appeals held that the phrase together with means in addition to. We've also cited cases from Texas and Oklahoma confirming the same. There's also a practical aspect to this, Your Honors. In a foreclosure waterfall scenario, one lien must be paid off before a subsequent lien could be paid off. So if we were to accept appellant's argument that, oh, if there's a fourth lien, they're subject to interest, but the borrowers are not, that's incongruent. That can't happen. If there is fourth lien subject to interest, then the borrowers must be subject to interest because they would be the ultimate recipients of any money left over at the end of a foreclosure if the sale generated more proceeds. Fourth, Your Honors, if the court perceives tension among any of the documents here, the parties themselves agreed on a provision of the loan documents, providing for a provision for control of which provision controls. And the language says, and it's in section 10Q of the loan agreement, which is incorporated again into the mortgage by that phrase. If there's any conflict in the loan documents, the provision which shall enlarge the interest of lender in the mortgage property or afford lender the greatest financial security in the mortgage property shall control. So again, $5 million loan, the parties agreed that in the event there is a conflict, the provision which gets lender the greatest control, financial security, or enlarge the interest of lender controls as to any other conflicting term. Appellants didn't address this argument in the trial court or in front of this court, Your Honor. We've cited the TST truck case.
And did you bring all those up?
Yes, Your Honor.
Okay.
And we've cited, Your Honor, the TST truck case. It's a Kansas Federal District Court case, I grant you, but a very similar clause enforced by the Kansas Federal Court, allowing inconsistent provisions to not create an ambiguity in the documents and enforcing the greater provision that gave the bank the most control. Appellants also argue absurdity, Your Honor, in the amount of the interest and attorney's fees exceeding the mortgage cap. Of course, appellants disregard the fact that they themselves are personally liable for the $1.7 million, regardless, all the interest, all the attorney's fees. So the fact that their residents may support those as well can't be absurd if they themselves are personally liable for it. They also didn't raise the absurdity argument below, so only in briefing to before this court, so it would be deemed waived. As to the homestead exemption, Your Honor, this doesn't bear much speaking, but it is obviously a mortgage here which waives the homestead protections and requirements, and therefore any sort of policy arguments don't apply. All right, switching to the Dunlap Declaration. There's a procedural question of the bank's compliance under Rule 141. First, the appellants did not make that argument in front of the district court that the bank did not comply with Rule 141, either at the hearing on that or by filing a separate motion to deem that fact admitted as the bank did in relation to the first summary judgment. So as it's not raised below, it can't be considered by this court. Second, the text of Rule 141 does not require converting facts raised in a summary judgment on reply. The controversion of facts in Rule 141 is specifically listed as to moving party and then the party opposing in parts A and B. Part C of that rule, which deals with replies, does not require that. Third, Your Honor, and this is undisputed, obviously, Rule 141D does allow objections to be made to statements of fact, which the bank did here, both as to hearsay and the plural evidence rule, both of which the court sustained. And as to the hearsay, Your Honor, the court did sustain on that as to scope of authority and agency. That was not briefed in the reply, not argued against at district court level at the hearing, and raised only in a footnote in appellant's opening brief in a case that didn't deal with authority of an agent to make a statement.
Let me go back and I'm going to ask you a question. I hope you all are very, very well versed on this, and it's probably a stupid question. But I'm trying to wrap my head around the fact that these people put up this $100,000 with their home as collateral, basically, right? Is that what happens if they default? This goes against can be collected from the proceeds from a sale of their home or something. Is that?
Let me answer that question, but let me give you a broader scope and then
please
down on that.
Right.
Okay, because it's a good question. So this was a commercial loan. So the main borrower here is Stonelock Global. Okay. Stonelock Global borrowed $5 million.
Right. I get that.
Granted all assets lien on all of its assets.
Right.
Okay. There were additional guarantees by the guarantors and $100,000 third mortgage on this residence. Okay.
Okay. So they take a third mortgage on the residence, come up with $100,000 in principal. And so to get $100,000 mortgage, a third mortgage on a resident, your residence has to be appraised and it has to be able to support value-wise that $100,000, right?
Yes, and I'm not exactly clear in normal loans, absolutely yes.
Okay.
In SBA third loan scenarios, I don't know if an appraisal is required, but if that's critical, I could certainly.
What's confusing me is, so if added on to that $100,000 is now interest and attorney's fees, doesn't there have to be some sort of belief that the value of the home can support whatever that might be?
Sure, you're right. And there's a practical component to that. Yeah, if the home, there's a practical component. Yes. Well, and yes, but also the SBA, and this is let me back up to 10,000 feet with the SBA guarantees. So, the SBA, the federal government in its wisdom said, okay.
So SBA is going to give you this deal.
Yes. Well, normal borrowers maybe can't qualify for traditional finance.
Right.
So the government, the SBA said, okay, lenders, we're going to incentivize you to go out and lend money to people who would normally qualify by guaranteeing downside risk if they default.
Right.
And we're going to do that under certain terms that we're going to outline in our authorization. Okay. So what that does is it sets the floor terms for each of those things. So the bank can go beyond those, certainly, with its borrower, because it's very clear in the SBA standard operating procedures, which are cited in our brief and then relied on by the trial court, that it's a separate deal. The SBA sets the terms of its authorization with the lender. The lender sets its separate terms of the loan with its borrowers. So if the lender wanted to, in this case, could it have gotten a $500,000 mortgage and still gotten the benefit of the SBA authorization? It could in this case. But again, it just sets the floor terms of what the minimums of what they have to do to gain the SBA guarantee.
I think the lien word made me think about, then the lien could be $300,000. And does the property support that amount of money? Is there a disconnect?
You're talking about
I'm not understanding.
You're talking about the underlying value of the property,
right?
It's a nice property. and in Leawood. And so there was,
I'm not suggesting that maybe there wasn't enough to support it, but the amount of money that could be added on to that $100,000.
I see, okay,
That's what I'm-
I see, I get where you're going. So the purpose of these mortgages from the SBA is not to support the value. It's to create leverage on the essentially principals beyond their guarantees, especially in states with homestead exemptions
Mhm,
from a bankruptcy risk.
To make sure they pay.
Yes.
right.
And so the value determination is not critical to this, like it would be with a regular home loan where you're like, okay, does this support my mortgage? This is a leverage security to help enforce payment on the loan and prevent essentially bankruptcy of the principals. And then,
Because one of the other that kind of ties into this, one of the other questions, I think, although I think there's a question of whether this was ever brought up to the district court, was if they wanted to redeem, if this came to pass and they wanted to redeem on their mortgage, what amount of money would it take to do that?
so it would depend on the bid. It would depend on the credit bid of the bank as to what it bid at the sale. So it's a
Right,
known amount. So if,
but if they wanted to redeem short of a sale, they just want to redeem the property, what would the amount?
so I see what you're saying. So yes, they're saying, okay, hey, can we just pay off the 100,000
Right.
right now? And the answer is no, because of the reason I just mentioned and the terms of the loan documents. Loan documents in the third mortgage, and I can pull it out
Okay,
if you want me to.
okay, no, I'm
And
just trying to understand how this fits together in what my mind would be the typical
sure,
mortgage lien situation. And you're saying it's atypical because it's this
it's
commercial,
typical in the SBA.
right,
I would say it's typical in the SBA, not typical to your HUD
right.
standard mortgage thing. So, and this issue is addressed in the reply to the second summary judgment as well, where this issue was brought up.
Uh-huh,
So there's terms in the
read it somewhere.
there's terms in the loan agreement which dictate where we can apply payments.
Uh-huh.
So we don't, if they walked in tomorrow with $100,000 check, we don't have to apply that to the mortgage under the loan agreement. We can apply that to principal, interest.
We'll do, okay.
Yeah, but we don't have to apply it to that specific debt. Number one. Number two,
Because they're on the hook for all of it regardless.
Exactly.
That's the point.
exactly.
Okay,
Number two, under the terms of the mortgage, it confirms the same thing, even in the event they weren't in default. So the day after they signed this, if they came in like, here's $100,000,
yeah,
take off the mortgage, and the mortgage specifically says, no, you can't do that. It's a last dollar mortgage, so it secures to the last dollar. And then three, in the forbearance agreement that was signed as part of this,
you're guaranteeing, that's guaranteeing the whole amount is paid, not just the 100,000.
the mortgage secures 100,000
Uh-huh.
in principal only. It does not, no, we've never taken the position it secures more than 100,000 in principal. Does secure interest and attorney's fees in addition to
Right.
that, but they can't just do a short payment of that and pay without paying off.
Okay, got it.
All right. No, I'm happy to answer any questions. So, we were talking about the Dunlap Declaration and Rule 141.
You'll have a couple minutes since I took a couple minutes.
Okay, I will speed up here. We talked about that. Parole evidence. All right, let's talk about parole evidence. They did not argue, to be very clear, that there was no argument that the mortgage was ambiguous
Right,
at the trial court.
I know that.
Okay. And the parole evidence rule is the reason these sorts of things exist. The alleged statement was 11 years ago on this, and ambiguity cannot be raised from parole sources. They can't introduce their own statement or an alleged statement of another party and say, here you go. Here's a statement. We'll use that statement to make that ambiguous, and then use that same thing to admit the statement. That's circular reasoning. Nelson case cited in our papers. Oral statements can't be used to vary terms.
And that seems to be what's happening here.
Exactly correct, Your Honor. You can't introduce your own statement. Therefore it's
Now it's ambiguous.
and therefore it's admitted.
Right.
It's circular.
Right.
Yeah.
Do you think, I mean, even, let's say we take all of the parole evidence they want us to take. Do you think that creates,
They still don't win.
okay, let's go ahead and give me a sentence on that.
Okay. So the reason they still don't win is it's an ambiguous statement, and the oral statement, okay, admitted It's in there, but it's still subject to parole evidence. And you can't then introduce it to contradict the mortgage. The mortgage is clear. They haven't argued it's ambiguous. There's no explanation of the language there. So, and again, it's completely reasonable to assume at the signing of the loan, is this limited to $100,000 when you're signing a $5 million loan to make sure there's not a $5 million loan on your house unexpectedly? Yeah, it's limited to $100,000. Completely reasonable to assume they're just talking about principal here. And to go into the 100 machinations you would have to do to explain, well, yeah, but if you don't pay taxes, then I can maybe do that. If you don't pay insurance, if there's a condemnation action, if there's an insurance action, all the hundreds of things that can happen during the life of a loan there that could impact that, to ask the bank to explain that to someone at a closing is just it's insane. Relationship of the parties, they raise that here. Fraud in the inducement, they only raised that on reply,
Right.
not raised at the trial court level, not raised in the answer, not raised in the opening brief, and all claims were waived in the forbearance agreement, so they couldn't even raise it anyway. The position of the parties phrasing, Your Honor, is what they're trying to do is to use that phrasing in cases to essentially do what the parole evidence rules forbids and say, okay, well, every statement of the parties at closing.
Okay, I'm gonna cut you
Thank
off. Okay, you have 3 minutes.
Thank you.
I'm gonna take the first. Last thing he said on first,
Okay, yeah,
the,
what I would do too.
well, I can remember it.
Mhm.
The parole evidence argument was made in our original brief. There was no waiver there. And this fits, as I hate to repeat myself.
I think he's saying though that the fraudulent stuff was only raised in your reply.
That is true. It was in response to something that they were talking about it. This didn't fit within, hearsay exceptions and all. And so that
Now, we have
part of the
pretty
response.
strict rules that we have been reminded by our Supreme Court many times before that we can't consider something that's brought up, an issue that's brought up for the first time in the reply brief.
Yes, I can represent to you that we have preserved that issue of the parole evidence and the reason for it. And the reason that the exception applies here, which was not adequately addressed by my colleague. As a matter of fact, there was no mention of the exception again to the hearsay rule
Right.
about this bank representative who is their front person on this loan telling them something. He said it was entirely reasonable for somebody to ask that. Yes, I agree. So now is the argument it's unreasonable for them to accept what they say is true? I mean, these are, again, this is a small business. It's owned by people who are lay people. And they're presented with a massive amount of documents. Maybe if they made a
sophistication, if they're ready to enter into a $5 million loan.
I don't disagree with that, but I would guess I would say if the Dunlaps made one mistake, is maybe that they took him for his word and not to get some official, declaration to that effect. But to say that that's not an issue in this case, or that it would not impact the court's decision making, based upon what he just told you, at a minimum, as I said before, there's a clear issue of fact as to what was the impact of that statement. What was it based upon? That could all be gone through and analyzed if and when the case is sent back, which at a minimum it should be, to root those issues out. Because the question might be, okay, well, how much should he tell them? Under what circumstances could it be more than $100,000? We could present evidence that absolutely contradicts that.
Mm-hmm.
And the whole point, Your Honors, is when that type of information is conveyed to which, however you want to look at it, there was no contra evidence presented that's before this court or that was before the district court. So that is the evidence that we have here, is that they were told this, that he was authorized, well, by all indications, he was authorized.
Right, evidence is the language of the contract and the ambiguity or not,
Well,
right? This would have been clear, this was clear in the contract, I'm just saying what the other viewpoint.
oh, well, sure, that would be the argument that which is the basic argument for parole evidence. You can't come in and attack something, but you can under certain circumstances.
Right.
And we believe those exist here because as I think I stated at the very outset, the goal here, I don't want to tell you your job, you know your job's better than I do, but is to derive what the intent of the parties is. And if there's evidence that relevant that goes to that intent, which we believe that declaration does, then it should be considered. And maybe it should be considered by a trier of fact, and maybe you're the tribunal that considers that, but it can't just be rejected out of hand for the reasons that we've stated. So with that,
Okay.
thank you for your patience.
Thank you very much.
Yeah.
Again, we've been very fortunate with this docket, very well-written briefs, great argument. Thank you for responding well to
Thank you.
all our questions, both of you, including my long trip down mortgage lane. Okay, we will stand in recess.